we are proceeding. Any body corporate whose board of director, managing director, manager in the ordinary course of business act on the advice, direction or instruction of a director, partner or manager of the corporate debtor. Then comes that any limited liability partnership, क्या कोई limited liability partnership देन कम्स दैट अगर कोई लिमिटेड लाइबिलिटी पार्टनरशिप है और पार्टनरशिप फर्म है जिसका पार्टनर और एम्प्लॉय इन द ऑर्डिनरी कोर्स ऑफ बिजनेस एक्ट्स ऑन द एडवाइस डायरेक्शन और इंस्ट्रक्शन ऑफ अ डायरेक्टर पार्टनर और मैनेजर ऑफ द कॉर्पोरेट डेटर तो हम क्या बोलते हैं अगर कोई लिमिटेड लाइबिलिटी पार्टनरशिप है या पार्टनरशिप फर्म है जिसके पार्टनर्स और एम्प्लॉयज इन द ऑर्डिनरी कोर्स ऑफ बिजनेस who acts on the advice, direction, or instruction of a director, partner, or manager of the corporate debtor. Any person on whose advice, direction, or instruction a director, partner, or manager of the corporate debtor is accustomed to act. A body corporate, which is a holding subsidiary or an associate company of the corporate debtor, or a subsidiary of holding company to which the corporate debtor is a subsidiary. Any person who control more than 20% of voting right in the corporate debtor on account of ownership or of voting agreement. Any person in whom the corporate debtor control more than 20% of voting rights on account of ownership or a voting agreement. Any person who can control the composition of board of director or corresponding governing body of the corporate debtor. Any person who is associated with the corporate debtor on account of participation in policy making processes of the corporate debtor or having more than two directors in common between the corporate debtor and such person, and interchange of managerial personnel between the corporate debtor and such person, and provision of essential technical information to and from the corporate debtor, section 5 subsection 24. Related party in relation to an individual means a person who is a relative of the individual or the relative of the spouse of the individual. A partner of limited liability partnership or a limited liability partnership or a partnership firm in which the individual is a partner. A person who is a trustee of a trust in which the beneficiary of trust includes the individual or the terms of trust confers a power on the trustee which may be exercised for the benefit of the individual. A private company in which the individual is a director and holds along with his relative more than 2% of its share capital. A public company in which the individual is a director and holds along with the relative more than 2% of its paid up share capital. A body corporate whose board of director, managing director or manager in the ordinary course of business act on the advice, direction or instruction of the individual. A limited liability partnership or a partnership firm whose partner or employees in the ordinary course of business act on the advice, direction and instruction of the individual. A person on whose advice, direction, or instruction the individual is accustomed to act. A company where the individual or the individual along with its related party own more than 50% of the share capital of the company or controls the appointment of the board of directors of the company. For explanation, for the purpose of this clause, relative with reference to any person means anyone who is related to another in the following manner, namely, the member of a Hindu undivided family, husband, wife, mother, son, daughter, son's daughter and son, daughter's daughter and son, granddaughter and son, granddaughter's daughter and son, brother, sister, brother's sons and daughter, sister's sons and daughter, father's fathers and mother, mother's fathers and mother. तो these are what these ये सारे जो है वो किसके definition में आते हैं relative में आते हैं. Member of the HUF family हम क्या बोलते हैं that members of the Hindu undivided family, then husband, then wife, then father, then mother, then son, then daughter, then son's daughter, and so on. Daughter's daughter and so daughter's daughter, so on. It is son, grandson, grandson, daughters and son, granddaughter's daughter and son, brother, sister, brother's son and daughter, sister's son and daughter, father's father, mother, mother's fathers and mother, father's brother and sister, mother's brother and sister, and wherever the relation is that of son, daughter, sister or brother, their spouse shall also be included. उसके बाद resolution applicant क्या है means a person who individually or jointly with any other person submits a resolution plan to the resolution professional pursuant to the invitation made under section 25(2)(h) or pursuant to section 54K 1000 the case as the case may be, that will be section 5 Subsection 25. Then resolution plan means a plan which is proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with part 2. Then for removal of doubt, it is hereby clarified that a resolution plan may include provision for the restructuring of the corporate debtor, includes by way of merger, amalgamation and demerger. Resolution professional for the purpose of this part means an insolvency professional who is appointed to conduct the corporate insolvency resolution process or the pre-packaged insolvency resolution process, as the case may be, and includes an interim resolution professional that includes an interim resolution professional. Then comes the voting share, means the share of the voting rights of a single financial creditor in the committee of creditor, which is based on the proportion of financial debt which is owed to such financial creditor in relation to the financial debt owned by the corporate debtor. Section 5, subsection 28. Corporate insolvency resolution process, section 4, 6 to 32 and 32A. तो प्रोविजन जो कि रिलेटेड है इंसॉल्वेंसी रिजोल्यूशन and liquidation process for corporate persons or are covered in part 2 of the code. This part comprises of 7 chapters with section 4 to 77 of the code. Each chapter deals with different issues relating to insolvency resolution and liquidation of corporate person. Corporate insolvency resolution process CIRP is a process during which the committee of creditors, जो कि committee है creditors की, that is a COC, assess whether the debtor's business is feasible. क्या जो debtor का business है क्या वो feasible है, viable है to continue. The option for its rescue and the revival if any, and endeavor is to keep it as going concern. If the insolvency resolution process fails or जो COC है, that is a committee of creditor, decide that the business of debtor cannot be revived, then the debtor will undergo liquidation process and the assets of the debtor shall be realized and distributed by the liquidator among the stakeholders as per section 53. जो liquidation है that can also be on an ongoing basis where the corporate debtor shall not be dissolved. The insolvency resolution process provides a collective mechanism to lenders to deal with the overall distressed position of a corporate debtor. This is a significant departure from their earlier legal framework under which the primary onus to initiate a reorganization process lies with the debtors and the lenders may pursue distinct action for recovery, security enforcement and debt restructuring. जो कोड है वो क्रिएट करेगा टाइम बाउंड प्रोसेस फॉर इंसॉल्वेंसी resolution of companies and individual. This process is to be completed within 180 days, extendable by 90 days. However, the overall process has to be completed within an outer time limit of 330 days. However, in certain exceptional cases, it may be open for the adjudicating authority or appellate tribunal to extend the time beyond 330 days. Jocode was also provides for fast track resolution of corporate insolvency within 90 days. If insolvency cannot be resolved, the assets of the borrowers may be sold to repay the creditors. What will be the process flow? क्या होगा? A comprehensive process that covers the gamut of insolvency resolution framework for corporate and include process relating to the filing of how there will be the filing of application before NCLT by a financial creditor, operational creditor or a corporate applicant, adjudication, admission or rejection of application if admitted, then moratorium and public announcement, appointment and of interim resolution professional, calling of claims, formation of committee of creditors, appointment of resolution professional, taking control and managing the operation of the corporate debtor by the IRP and RP, appointment of registered valuers, preparation of information memorandum and invitation for expression of interest, then submission of expression of interest by prospective resolution applicants, then preparation of provisional and final list, preparation of provisional and final list of resolution applicants by the resolution professionals, issue of requests for resolution plan, information memorandum and evaluation matrix to all the prospective resolution applicants. There will be the submission of resolution plan by resolution applicants, then approval or rejection of the resolution plan by the क्रेडिटर्स ऑफ कमिटी और वो जो सीओसी बार बार जो आ रहा था. देन अप्रूवल और रिजेक्शन हो सकता है ऑफ द रेजोल्यूशन प्लान बाय द एनसीएलटी, दैट इज द एडजुडिकेटिंग ऑथोरिटी. इम्प्लीमेंटेशन ऑफ रेजोल्यूशन प्लान इफ अप्रूव्ड बाय एनसीएलटी. CIRP overview default by corporate debtor, filing of application with the adjudicating authority. There will be the appointment of interim resolution professional, formation of committee of creditors, invitation of expression of interest, preparation of information memorandum by RP, appointment of resolution professional, submission of resolution plans by resolution applicants. There will be the evaluation of resolution plans by COC. resolution plan जो है वो approve होगा by COC. resolution plan जो है वो reject होगा by COC. resolution plan approve होगा by adjudicating authority. resolution plan जो reject होगा that will be also by the adjudicating authority. Then the liquidation. फर्दर हम पढ़ रहे हैं दैट इज व्हाट विल बी द एप्लीकेशन टू नेशनल कंपनी लॉ ट्रिब्यूनल. जो प्रोसेस है इंसॉल्वेंसी का वो ट्रिगर्ड होगा बाय द अकरेंस ऑफ डिफॉल्ट एज पर सेक्शन 3 subsection 12 of the code. Default means non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor. So provision है जो भी है relating to the insolvency and liquidation of corporate debtor shall be applicable only when the amount of default is 1 lakh rupee or more. However, जो central government है that the same by notification dated 24th March 2020 raised the threshold value of minimum amount of default to 1 crore rupee, provided further that जो central government है may by notification specify करेंगे such minimum amount of default of higher value which shall not be more than 1 crore rupee for matters relating to pre-packed insolvency resolution process of corporate debtors under chapter 3A. Filing of application before NCLT. जो कॉर्पोरेट इंसॉल्वेंसी प्रोसेस है वो इनिशिएट हो सकती है अगेंस्ट एनी डिफॉल्टिंग कॉर्पोरेट डेटर बाय मेकिंग एन एप्लीकेशन फॉर कॉर्पोरेट इंसॉल्वेंसी रेजोल्यूशन प्रोसेस बिफोर द एनसीएलटी. कौन इनिशिएट कर सकता है इंसॉल्वेंसी? हु कैन, हम क्या बोलते हैं दैट who can initiate insolvency resolution process. कौन initiate कर सकता है? where any corporate debtor commits a default. जब कभी भी corporate debtor जो है वो default करेगा तो an operational creditor or the corporate debtor itself may initiate corporate insolvency resolution process in respect of such corporate debtor in a manner as provided under this chapter 2 of part 2 of section this. प्रोविजन एंड प्रोसीजर जो भी होगी रिलेटिंग टू ईच इनिशिएटर्स वो डिफरेंट हो सकती है. अकॉर्डिंगली जो एप्लीकेशन है मे बी मेड बाय फाइनेंशियल क्रेडिटर के थ्रू हो सकती है. एनी पर्सन टू हुम अ फाइनेंशियल डेट इज ओन एंड इंक्लूड्स अ पर्सन टू हुम सच डेट इज लीगली असाइंड और ट्रांसफर्ड. Operational creditor, any person to whom operational debt is owned and includes a person to whom such debt is legally assigned or transferred. Corporate debtor, a corporate person who owns a debt to any other person and committed default. Initiation of corporate insolvency resolution process by financial creditor. Filing of application before adjudicating authority, a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred, provided that for the financial creditor referred to in clause A and B of subsection 6A of section 21, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such creditor in the same class or not less than 10% of the total number of such creditor in the same class whichever is less, provided further that for financial creditor who are allottees under a real estate project, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project or not less than 10% of the total number of allottees under the same real estate project whichever is less. For the purpose of this subsection, a default includes a default in respect of financial debt which owned not only to the applicant हम ये बोल रहे हैं that for the purpose of this subsection, a default includes a default in respect of financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. By notification this, the central government hereby notified that following person who may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority on behalf of the financial creditor. A guardian, an executor, tutor or administrator of an estate of financial creditor, a trustee including a debenture trustee, and a person duly authorized by the board of directors of the company. What will be the procedure to be followed by the financial creditor? What will be क्या procedure होगी to be followed by the financial creditor? The financial creditor shall file an application by itself jointly against a corporate debtor before NCLT in accordance with the provision contained in Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. जो भी copy होगी of such application shall be forwarded to the register office of corporate debtor and to the board by registered post, speed post, by hand or by electronic means before filing the adjudicating authority. Financial creditor shall along with the application furnish record of the default recorded with the information utility or such other record evidence of default as may be specified. उसके बाद हम बोलते हैं the name of the insolvency professional proposed to act as an interim resolution professional and any other information as may be specified by the board. What will be the time period for determination of default? The adjudicating authority shall within 14 days of receipt of the application ascertain the existence of default from the records of information utility or on the basis of other evidence furnished by the financial creditor. Then, provided that if the adjudicating authority has not ascertained the existence of default and pass an order within such time as specified, it shall record its reasons in writing for the same. What will be the case log है? Supreme Court in Surendra Trading Company versus Jugilal Kamla Pat Jute Mills Company Limited and other prescribed time period for determination of defaults. It was held that the time limit prescribed in IBC 2016 for admitting or rejecting a petition or initiation of CIRP under proviso to subsection 5 of section 7 or subsection 7 of section 9, subsection 4 of section 10 is procedural in nature, a tool of aid in expeditious dispensation of justice and is directory. Various provision of the code would indicate that there are the three stages. There will be three stages. फर्स्ट स्टेज क्या होगा? फाइलिंग. सबसे पहले क्या करना होगा? हमें फाइल करना होगा ऑफ द एप्लीकेशन. व्हेन द एप्लीकेशन इज फाइल्ड, जैसे ही एप्लीकेशन फाइल्ड होगी तो रजिस्ट्री जो होगी ऑफ द एडजुडिकेटिंग अथॉरिटी इज सपोज टू वो स्क्रूटनाइज होगी द सेम टू फाइंड आउट एज टू वेदर इट इज कंप्लीट है क्या है इन ऑल रिस्पेक्ट और देर आर सर्टेन डिफेक्ट. इफ इट इज कंप्लीट the same shall be posted for preliminary hearing before the adjudicating authority. If there are defects, the applicant would be notified about those defects so that these are removed. For this purpose, 7 days time is given. Once the defects are removed, then the application would be posted before the adjudicating authority. उसके बाद आएगा हमारा द सेकेंड स्टेज. देन कम्स द सेकेंड स्टेज. सेकेंड स्टेज क्या है? व्हेन द एप्लीकेशन इज लिस्टेड बिफोर द एडजुडिकेटिंग अथॉरिटी. जब एप्लीकेशन जो है लिस्ट होगी बिफोर द एडजुडिकेटिंग अथॉरिटी, इट हैज टू टेक अ डिसीजन टू आइदर एडमिट और रिजेक्ट करे द एप्लीकेशन. फॉर दिस पर्पज 14 days टाइम इज ग्रांटेड टू द एडजुडिकेटिंग अथॉरिटी. अगर एप्लीकेशन जो है वो रिजेक्ट हो गई तो द मैटर इज गिवन इन दी quite as that at that level itself. However, if it is admitted, we enter the third stage. Then third stage, after admission of the application and application is admitted, insolvency resolution process commences. This resolution process is to be completed within 180 days, which is extendable in certain cases up to 90 days. In so far as the first stage is concerned, it has no bearing on the insolvency resolution process at all. In as much as unless the application is complete in every respect, the adjudicating authority is not supposed to deal with the same. It is at the second stage that the adjudicating authority is to apply its mind and decide as to whether the application should be admitted or rejected. Here the adjudicating process starts. However, in spite thereof, when this period of 14 days given by the statute of to the adjudicating authority to take a decision to admit or reject the application is directory, there is no reason to make it mandatory in respect of first stage, which is pre-adjudication stage. Thus, provision जो है of removing the defects within 7 days is directory and not mandatory in nature. तो मैंडेटरी नहीं होगी नेचर में. द इंसॉल्वेंसी एंड बैंक्रप्सी कोड 2016 ऑर्डर वेयर द एडजुडिकेटिंग अथॉरिटी satisfied में either admit कर सकता है application when a default has occurred and the application is complete, no disciplinary proceeding pending against the proposed resolution professional, rejected application when default has not occurred or the application is incomplete, or any disciplinary proceeding is pending against the proposed resolution professional. Notice to rectify the defect in the application, provided that adjudicating authority shall, before rejecting the application, give a notice to the applicant to rectify the defect in his application within 7 days of receipt of such notice from the adjudicating authority. It is applicable for all kind of application filed by financial creditor or operational creditor or by the corporate debtor. Commencement of corporate insolvency resolution process. The corporate insolvency resolution process shall commence होगी from the date of admission of the application. Then communication of order का जो adjudicating authority shall वो communicate करेगा order of admission or rejection of such application within 7 days, as the case may be in case of admission to the financial creditor and the corporate debtor, and in case of rejection to the financial creditor. Then comes the withdrawal of application. Then comes what? The withdrawal of application. What will be the withdrawal of application? क्या है? Withdrawal of application shall be pursuant to section 12A of the code. Read the regulation 30A of the IBBI, insolvency resolution process for corporate person, regulation 2016. The following scenario may arise for withdrawal of application. Before admission of application admission of application से पहले an application initiating the CIRP may be withdrawn before its admission at any time with the permission of the adjudicating authority. Rule 8 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. After admission of application, once application is admitted, further 3 scenarios may arise. 3 scenarios जो है वो arise होते हैं. Before consideration of COC, after consideration of COC, and after issue of invitation for EOI. तो हम क्या बोलते हैं? Before consideration of COC, जो application है that shall make an application for withdrawal to the adjudicating authority through the interim resolution professional. Then after consideration of COC, but before issue of invitation for expression of interest, and an application for withdrawal shall be firstly considered by the COC within 7 days of its receipt. Such withdrawal application shall be approved by the COC with 90% voting share, upon which the resolution professional shall submit such withdrawal application along with the approval of the committee to the adjudicating authority on behalf of the applicant within 3 days of such approval. After issue of invitation for EOI, the same procedure as stipulated for scenario B above shall apply. However, in this scenario, the applicant shall state the reason justifying the withdrawal after issue of such invitation. In all the above scenarios, the final approval of such withdrawal shall be by way of an order passed by the adjudicating authorities. National Company Law Tribunal Mumbai Bench in Bank of India versus the Future Retail. This page number is 28 and it is around 54. Not 54, 73. 73. 57. National Company Law Tribunal Mumbai Bench in Bank of India versus of Future Retail Limited in 2022 came with an issue where a financial creditor has provided various credit facilities and loan fund based limits to corporate debtor. It were restructured under a sanction letter and framework agreement. Corporate debtor defaulted in repayment and account of corporate debtor was classified as a non-performing asset. Meanwhile, corporate debtor issued a letter to financial creditor and certain other lenders for one-time restructuring. Facilities under Resolution Framework Agreement for COVID-19 related stress as per the RBI circular, financial creditor considered corporate debtors Corporate debtor again defaulted in repayment of an outstanding amount. Financial creditor filed petition under Section 7. It was noted that the corporate debtor on payment of obligation under the OTR scheme admitted default of its repayment, and further corporate debtor admitted outstanding amount in its meeting with lender that events of default continue to subsist. It was held in view of the fact that existence of debt and default has been proved, and therefore petition filed by the financial creditor to initiate the CIRP against corporate debtor was admitted. The Insolvency in Bankruptcy Court 2016. National Company Law Appellate Tribunal, New Delhi in 2022 in City Networks Limited Assets Care and Reconstruction Enterprises Limited decided on continuation of proceeding by assignee on an application seeking substitution as financial creditor in place of original financial creditor. In the given case, financial creditor sanctioned a loan to corporate debtor. However, corporate debtor failed and was classified as non-performing asset. Financial creditor filed an application under Section 7 against corporate debtor and same was admitted by NCLT. Later, financial creditor White registered assignment deed assigned debt of corporate debtor to respondent, that is assignee. Corporate debtor was informed about aforesaid assignment. Subsequently, assignee filed an application seeking substitution as financial creditor in place of original financial creditor and was permitted by NCLT to pursue application filed by original financial creditor. Challenging said order, instant appeal was filed by corporate debtor. It was held that Section 5, subsection 7 of the code defined financial creditor also includes a person to whom such debt has been legally assigned or transferred to. Therefore, by virtue of assignment, assignee become financial creditor and had stepped in shoes of original financial creditor, and assignee had every right to continue proceeding which was initiated by original financial creditor. SC in Manish Kumar versus Union of India in 2021 came up with a decision on Section 7 by Section 3 of IBC Amendment Act 2020 requiring the minimum threshold for initiation of proceeding class action by certain categories of financial creditors against corporate debtors such as real estate developers are constitutionally valid. In the given case, CIRP was initiated by the financial creditor requiring the minimum threshold for initiation of proceedings class action by certain categories of financial creditors against corporate debtors such as the real estate developers. According to provision of Section 7, it was required that in case of real estate project being conducted by corporate debtor, an application can be filed by either 100 allottees or allottees constituting 1/10 of allottees, whichever is less, if they are able to establish a default in regard to financial creditor, and it's not necessary that there must be default qua any of applicants. It was held that since default can be qua any of the applicant and even a person who is not an applicant, and action is one which is understood to be RAM, in that procedure under court would bind entire set of stakeholders including whole of allottees. Initiation of corporate insolvency resolution process by operational creditor. Serving of demand notice on the occurrence of default, and operational creditor shall first send a demand notice and a copy of invoice to the corporate debtor in such a form and manner as may be prescribed. Demand notice means a notice which is served by an operational creditor to the corporate debtor demanding payment of the operational debt in respect of which the default has occurred. On receipt of demand notice by corporate debtor, the corporate debtor shall, within a period of 10 days of the receipt of demand notice or copy of the invoice, bring to the notice of operational creditor about the existence of dispute about that, if any record of the pendency of suit or arbitration proceeding filed before the receipt of such notice or invoice in relation to such dispute. The payment of unpaid operational debt, it is possible that the corporate debtor might have already paid the unpaid operational debt. There is such a situation, corporate debtor will inform within 10 days by sending an attested copy of the record of electronic transfer or the unpaid amount from the bank account of the corporate debtor, or by sending an attested copy of record that the operational creditor has in cash a check issued by the corporate debtor, that is Section 8. Now comes the There will be the application for initiation of corporate insolvency resolution process by operational creditor after issue of demand notice. Filing of application by operational creditor if no reply is received or payment or notice of the dispute under Section 8, Subsection 2 from the corporate debtor within 10 days from the date of delivery of the notice or invoice demanding payment, or even if the reply is received disputing the claim when operational creditor feels that the dispute is vague, untenable, operational creditor can file application before adjudicating authority NCLT for initiating a corporate insolvency resolution process. Providing of document information, the operational creditor shall, along with the application filed in prescribed form, furnish the following documents: a copy of the invoice or demand notice demanding payment or delivered by the operational creditor to the corporate debtor, an affidavit to the effect that there is no notice given by the corporate debtor relating to a dispute of the unpaid operational debt, a copy of the certificate from the financial institution maintaining the accounts of the operational creditor confirming that there is no payment of an unpaid operational debt by the corporate debtor if available, a copy of record with information utility confirming that there is no payment of an unpaid operational debt by the corporate debtor if available, and any other proof confirming there is no payment of unpaid operational debt by the corporate debtor, and such other information as may be prescribed. There may be the appointment of IRP, and operational creditor initiating a corporate insolvency resolution process may propose as insolvency professional to act as an interim resolution professional. There may be the order of an adjudicating authority. The adjudicating authority shall within the 14 days of the receipt of the application by an order admit कर सकता है the application and communicate कर सकता है such decision to the operational creditor and the corporate debtor if जो application है made is complete हो गई and there is no payment of the unpaid operational debt, the invoice or the notice for the payment to the corporate debtor has been delivered by the operational creditor, no notice of dispute has been received by the operational creditor, or there is no record of dispute in the information utility. There is no disciplinary proceedings pending against any resolution professional proposed, if any. Reject the application and communicate such decision to the operational creditor and the corporate debtor if the application made is incomplete and there has been payment of the unpaid operational debt, the creditor has not delivered the invoice or notice for payment to the corporate debtor, notice of dispute has been received by the operational creditor, or there is a record of dispute in the information utility. Any disciplinary proceeding is pending against any proposed resolution professional, provided that the adjudicating authority shall, before rejecting an application which is incomplete, give a notice to the applicant to rectify the defect in his application within 7 days of the date of receipt of such notice from the adjudicating authority. Withdrawal of application before or after the admission. The same procedure as stated under initiation of CIRP by financial creditor shall apply here as well as for withdrawal of application. Commencement of insolvency resolution process. So corporate insolvency resolution process जब वो commence होगा from the date of admission of the application. As in the matter of Mobile Locks Innovations Private Limited, OS is the Kirusa Software Private Limited Civil Appeal number 9405 of 2017 DT 21st September 2017, it was decided that in section 9 application, if there is a dispute, then it cannot be admitted. It should not feeble legal argument or an assertion of facts unsupported by evidence, and it need not be spurious, mere bluster, plainly frivolous, or vexatious. The National Company NCLT, a National Company Law Appellate Tribunal, Chennai Fipola Retail India Private Limited, M21 Interiors in 2021 admitted the application filed by operational creditor under Section 9 against corporate debtor in name of proprietary concern. Corporate debtor alleged that the said application would not be maintainable as application had been filed in name of proprietary concern, which is not a person for purpose of filing application under Section 9. It was held that such an application was maintainable as Section 2 subsection F provides that provision of code shall apply to partnership firms and proprietorship firm also. Then comes the initiation of corporate insolvency resolution process by corporate applicant. तो commission of default क्या है? Where a corporate debtor has committed a default, a corporate applicant thereof may file कर सकता है an application for initiating the corporate insolvency resolution process with the adjudicating authority. The application shall be filed in such a form containing such a particular in such a manner and accompanied with such fee as may be prescribed. Then When the corporate applicant means a corporate debtor, member or partner of the corporate debtor who is authorized to make an application for the corporate insolvency resolution process under the constitutional document of the corporate debtor, an individual who is in charge of managing the operations and resources of the corporate debtor, a person who has the control and supervision over the financial affairs of the corporate debtor. Constitutional document in relation to corporate person includes the article of association, memorandum of association, or a company and incorporation document of a limited liability partnership. Furnishing of information, the corporate applicant shall, along with the application, furnish the information relating to its books of account and such other documents relating to such period as may be specified. The insolvency professional proposed to be appointed as an interim resolution professional. Special resolution passed by shareholders of the corporate debtor or the resolution passed by at least 3/4 of the total numbers of partners of the corporate debtor as the case may be, approving filing of the application. Admission rejection of the application to adjudicating authority shall within a period of 14 days of the receipt of application by an order admit karega the application if it is complete and no disciplinary proceeding is pending against the proposed resolution professional. Reject karega the application if it is incomplete or any disciplinary proceeding is pending against the proposed resolution professional. Provided that the adjudicating authority shall, before rejecting an application, give a notice to the applicant to rectify the defect in his application within 7 days from the date of then comes the provided that the adjudicating authority shall, before rejecting an application, give a notice to the applicant to rectify the defect in his application within these 7 days from the date of receipt of such notice from the adjudicating authority. NCLT Mumbai bans in this 10th October in a matter of IGOPL Offshore Private Limited has pronounced that Section 10 subsection 3C of the code requires that a special resolution passed by the shareholder of the corporate debtor needs to be filed along with the company petition. Then commencement of insolvency resolution process. जो corporate insolvency resolution process है वो commence होंगे from the date of admission of the application. Then suspension of initiation of corporate insolvency resolution process. Notwithstanding anything contained in Section 7, 9, and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on and after 25th March 2020 for the period of 6 months or such further period not exceeding the 1 year from such date as may be notified in this behalf. Provided that no application shall ever be filed for initiation of corporate insolvency resolution process of corporate debtor for the said default occurring during the said period. For the removal of doubt, it is hereby clarified that the provision of this section shall not apply to any default committed under the said section before the 25th March 2020. The provisions of Section 10A was extended twice and it was applicable for default up to 25/3/2021. Persons who are not entitled to initiate insolvency process. Following persons shall not be entitled to initiate the corporate insolvency process. A corporate debtor who is undergoing an insolvency resolution process or a pre-packaged insolvency resolution process. A financial creditor or an operational creditor or a corporate debtor undergoing a pre-packaged insolvency resolution process. A corporate debtor having completed corporate insolvency resolution process 12 months preceding the date of making the application. A corporate debtor in respect of whom a resolution plan has been approved under Chapter 3rd A 12 months preceding the date of making of the application. A corporate debtor or a financial creditor who has violated any of the terms of the resolution plan which was approved 12 months before the date of making an application. A corporate debtor in respect of whom a liquidator order has been made. Explanation 1. For the purpose of this section, a corporate debtor includes a corporate applicant in respect of such corporate debtor. For the purpose of this section, it is hereby clarified that nothing in this section shall prevent a corporate debtor referred to in clause A to D from initiating corporate insolvency resolution process against another corporate debtor. Section 11. Following categories of corporate debtors not entitled to file an application under Section 11. Corporate debtor undergoing CIRP double PIRP, a financial creditor, operational creditor undergoing the double PIRP, corporate debtor having completed the CIRP 12 months before the date of making of the application, a corporate debtor in respect of whom a resolution plan has been approved under the कॉर्पोरेट डेटर जो कि वायलेट कर रहा है द टर्म्स ऑफ रेजोल्यूशन प्लान एंड कॉर्पोरेट डेटर इन रिस्पेक्ट ऑफ whom a liquidation order has been made. उसके बाद then comes the example. We are on page number 35. Still we are left with 15 page, but we need to make it